All right. Welcome, everyone. Welcome, welcome, welcome. We're getting a few things together here. There we go. All right. So, good morning, everyone. My name is Christian McCray Stewart. I am the founding attorney of McCray Stewart and Associates, your trusted advocates for justice and peace of mind. And today, of course, we are doing our estate planning webinar in line with our Pro Bono Initiative. So, as we all are logging on to the webinar, I want you to go ahead and like and share. I want you to share the link, invite people to come and join you. Just hit that share button and you'll be able to text it to other individuals, whether you're joining us on Facebook, YouTube, or LinkedIn. Get this information out. This is going to be a great time that we're going to have together just to share with you all some knowledge and insight in regards to estate planning, also information that will be valuable to some of you who actually may be eligible for us to assist you with your estate planning for free, right? But we know that knowledge is power. And so that is what we're coming to do today, to educate everybody and to get us all on the same track that we need to be. Also, shoot in the chat. If you have questions, you can definitely put them there. Let us know where you're joining in from, right? So we're going to give a few seconds here. I want to allow some other people to log in or to go ahead and join the webinar, and then we're going to go ahead and get started. I want to respect everybody's time, but it's truly a pleasure to have you all joining us. And the team is also in the chat. Shout out to Emil. Shout out to Tremaine. Thank you all so much for being there. So we're monitoring everything. Like I say, have questions, throw it in there. If you're just joining on, go ahead and like and share the video. Go ahead and also you can send a text message to some people and say, hey, look, this webinar is live. Estate planning. It is essential information that all of us need. If you happen to have questions, please go ahead and drop them in the chat. Drop them in the chat. All right. Okay, so just a little bit. Of course, you all know me. I've introduced myself. What we're wanting to do here with estate planning is provide and equip our community with information that's needed to be able to build wealth as well as protection for the next generations to come. Unfortunately, in a lot of our communities, people are not having these conversations. People are not actually planning. And what we see on the other end of this spectrum is that individuals pass and they don't have things in place, and it causes a headache. It's a trying time and for their family, and at a time when they should be truly remembering you, the good moments. You have a lot of individuals who are thrown into probate court. They're trying to navigate all the ins and outs, and it's a season of stress, which it does not have to be if we're able to put these things into place. And then a lot of us, we're out here, we're building businesses and all these different things. You want to build something for the future generations where there's tools out there that will assist you in doing these things the right way, right? And so that's some of the information that we're going to be sharing throughout the webinar. As I stated, any questions, go ahead and drop them in the chat. And then what I'm going to do is let us go ahead and jump into our discussion. So, educational presentation on wills and legacy planning. Also, if you are not already following us on our various social media platforms, Facebook, YouTube, LinkedIn, go ahead and do that because you'll always be abreast of information that's going on, information that we're putting out there, additional pro bono initiatives that we're going to take place, and you know where to find us. So a little bit about me. One thing in us doing this is that I feel like we're all blessed to be a blessing, right? And so there's knowledge, information, insight that I have. And so we don't want to hoard that. We want to present it to you all. We want to equip the people to do what they need to do. So I love what I do. Being an attorney is not just, a career. It's truly a calling. And then with that, I have the amazing opportunity to be a wife and a mother to two beautiful children. I graduated from Ole Miss Law in 2012. And I'm licensed in Mississippi, Texas, and Georgia. And hey, we've just been rocking on, truly desiring to help people and pursuing that justice and being the peace of mind that they need. Here's some of the information that we're actually going to cover, not this afternoon, but this morning. One thing being in the military is like, look, bottom line up front, we're going to get you information, break it down, what estate planning actually is, why it matters, some of the key components, wills, power of attorneys, healthcare directives, all these different things. When you think about estate planning, it's not simply just having a will. There's a lot of other things that come in in line with that. And of course, we're going to present to you about the Pro Bono Initiative, provide some insight for individuals to let them know what the criteria is to actually qualify, and then the next steps to actually get your information submitted. All right. So let us jump in. When we're talking about estate planning, it's the process of arranging for the management of your assets, everything that you've acquired in life. What is going to happen to those things when your time comes, right? This is things for you to have in place during life and after death. A lot of people don't want to have the discussions because they think, okay, if I begin to start estate planning, then that means that I'm manifesting or insinuating that something's going to happen. No, it's not. But if you fail to plan, then you plan to fail. And you don't want to do that. If you also probably heard this, well, hey, look, when you go, you can't take it with you. No, you can't, but you are in control of what's going to happen to your assets, to what you've built when your time comes. Okay. So you want to ensure that your assets are distributed according to your wishes. If you don't do it, guess who will? The state will. The state will dictate what is going to happen. So if you don't want to have the discussion, you don't want to take the time to say, look, I've been working through all these things. I built this up. This is how I want it to be distributed. These are the things that I want to donate to. This is how I want my children to be taken care of. This is how I want to assist them in being able to continue to build generational wealth. This is how I want things to look. If you don't, someone else will. Okay? Minimize taxes and legal consequences. There are different avenues, right? There are different tools in your toolbox that you have when it comes down to estate planning that can assist you with taxes, that can assist your loved ones with minimizing any potential legal complications that may arise when that time comes. And you're protecting and you're providing for your loved ones. That's wisdom. That's wisdom, to protect and provide for your loved ones. So that's essentially, in a nutshell, what estate planning is. Why does it matter? There's tools there that you can actually avoid probate. Simply just having a will doesn't get you out of probate. Let me be clear about that. Having a will is essential, depending on where, for everyone, regardless of where you are in life, having a will is essential. Now, when we get to the conversations of avoiding probate, then there's other tools that we want to pull out of our toolbox. We deal with trust. You have irrevocable trust, revocable trust. But we're having these conversations to determine what's going to best suit you as an individual, what you're looking to accomplish in the future, right? And so you can streamline some of these transfer of assets without lengthy court processes. Probate can be expensive. Probate can be costly, right? And if you're planning ahead of time, these are probably some things that you can prevent and avoid for your loved ones down the road. You want to ensure that the financial security of your family. So all of us, if you do not have it, you should have life insurance policies in place, right? And then with those policies, what does it look like? Have you listed out the necessary beneficiaries? If you have those beneficiaries, do you want to create a trust, right? If you have minor children, even if you don't have minor children. I just had a consult with someone and she was like, look, no, I don't have minor children. My son is this age, but I still want to be able to kind of dictate a little bit how he's going to do this so that he's continuing to build this wealth and the money's not just squandered, right? Protect your assets. There's a way to shield assets from creditors and legal claims. People file lawsuits against individuals all day, every day. What are you doing to protect yourself and your loved ones? Plan for incapacity. You never know what can happen, right? For one, tomorrow's not promised to any of us. We do not have one of those magical balls that tells us, okay, on this day, X, Y, and Z is going to take place. Anything can happen. And so if you're a business owner, what happens if you're at a place where you can't make decisions, right? Is your business just going to be shut down? Do people have the capability to access your bank accounts to continue to manage the expenses so your business continues to flow and do the things that it needs to do to continue to generate that revenue, right? If you're at a place you can't make decisions for yourself when it's regarding your health, have you put some things in place, an individual in place who can assist you so that you're taken care of, so that your wishes are being honored? If we don't do these things ahead of time, you then kind of relinquish all of your control, all of your authority over to other people to make decisions for you. And they may not make them in alignment with your moral values. They may not make them in alignment with what you have truly stood firm on throughout the duration of your life. So estate planning allows you to maintain your control. It allows you to maintain your authority. It allows you to maintain those things and then have the necessary parameters in place to ensure that it continues to follow. Yes. And so as you heard, also loving being a mom, you probably hear my little one in the back. So some key components of the estate plan. Of course, your will, I mentioned that. Trust. In all situations, you have that discussion and you determine what trusts are actually good for you, right? It's not a one size fits all when it comes down to these estate planning discussions, right? For individuals, some may need a trust and it's going to be a revocable trust so they can pull assets out, put them back in. Some, for various reasons, different benefits that they're trying to qualify for. Maybe you're a veteran and you need to ensure, you have multiple businesses, how things are shaped so that you don't miss out on those benefits. You still qualify for potential government contracts. Maybe an irrevocable trust is going to be more suitable for you. But this is the point of having the discussions. The power of attorneys, individuals who can act on your behalf to make those decisions for you when you can't, right? Or say you're out here, you're building multiple businesses, right? And you're traveling somewhere and you need to close the deal, but you're not here to sign off on the paperwork. Well, guess what? If you have a power of attorney in place, you can send these people, hey, look, there's a meeting at such and such time. I need you to be there to execute those documents. So this is why I want to have the discussion. When we talk about estate planning, it's more than just, oh, you're preparing for the time that you're getting ready to leave. No, you are continuing to prepare to continue to build wealth. You're preparing to have things in place so that your life continues to move freely, continuously. The dreams that you're having, you're walking to ensure those things come into fruition. You're planning so things that what you're producing, you're leaving a legacy, right? And when I talk about legacy, it's beyond just the financial aspect of it. For those of us who have children, they're going to be observing and watching what you're doing. So are you teaching them these things now? Dealing with your healthcare directives. If you encounter a situation, do you want life-sustaining treatment? Do you not want life-sustaining treatment? What treatment do you want? Do you want blood transfusion? This is the decisions that you're able to make. Beneficiary designation. This is important. You have 401ks, you have life insurance, you have stock accounts. Changing those beneficiaries, right? Who do you want those things to go to? If you create a trust, updating it so that it goes into your trust and it's going to be distributed based on the terms that you've set out. But being mindful, I have some people, I've encountered situations with families when we're on the probate aspect of this, and they're like, well, look, they had a 401k or they had this account, but guess what? Nobody was listed as a beneficiary. That we don't want those things to happen because these are type of accounts that passes outside of probate. So when we're failing to plan, what happens is we put our family in situations that they're having to go through the probate process that can take any 6 months on. We have cases that it's 2 years and they're still ongoing because the necessary things were not considered and they were not put in place. And the thing is, we don't want that to happen. Like I say, we see this on both ends. And so this is another reason why we're coming out here to provide this information so that people can start having the conversations, people can start planning, and people can start doing what needs to be done. Okay, so when we talk about wills, as I mentioned earlier, wills do require probate, right? If you have a will, it's going to go through probate. There is no ifs, ands, buts about it, okay? Wills become effective upon death. Wills are also public record. So individuals will know what assets you had, how you were distributing them, all those different things. For the most part, they're easy to update. You can name guardians for your children, which is important. And so this is why I'm saying, even if you're in a situation where you may not have to do a trust and things of that nature, just depending on where you are in life, the assets that you have, and what you're trying to do in the future, if you have children, you want to be able to set these things up. It's key. Individuals who you trust, right? A lot of people, well, we've seen a lot of situations, you all have probably encountered of some aspect or another, that an individual passes, they have minor children. Who's going to take care of those minor children? Discussions were never had. There was never any planning taking place. There's nothing to set out that this person is going to be the person who's going to look over those children, continue to guide them and direct them. And sometimes, let's just be honest. You may not necessarily want your children to go to someone in your family. Maybe you have a close friend who has become like blood, and they share your same values. Share your same insight. They know what you're desiring for your children in the future and how you're bringing them up and all those different things. And you feel that that person would be better suited to take care of your children. But if you don't prepare and put these things in writing so that it can be executed, so that it can be honored, then what happens? Everybody's running around there trying to figure out, okay, who are the children going to be with? Are the children going to be split up? Estate planning is essential. It is important for more than just one reason. Yes, are your assets going to be distributed to the beneficiaries through the process? Yes, it is. But I want people to really hone in that it's so much more than that, okay? Now, it does not, when you have a will, it does not manage assets while minors are under the age of 18. This is why in situations that we do discuss trust, we are able to kind of walk our clients through, look, hey, this is how it's beneficial, especially if you do have minor children, okay? You're transferring your assets at that time. Assets can be frozen. One thing about it, when you have a will, if you do not have individuals like on these accounts, they will not be able to access anything or do anything until they initiate that process and receive what they refer to as letters of testamentary in the court. So this is why we have those consults, and we try to tell people, look, these are things that you can do to potentially minimize probate. But if this is a situation, we want you to understand what it is. And for the most part, wills are affordable. Definitely with us, we try to provide a baseline so that no one is in a position that they do not have these things simply because they cannot afford it. That should never be the case. All right. Okay, power of attorney. We've kind of touched on some of these, but your financial power of attorney. You're designating someone who can manage your financial affairs, right? Open bank accounts for you, close bank accounts. One question, do I need a will if I already have beneficiary designations? So if you have, great question. If you have beneficiary designations, that's going to be great. But I'm always going to recommend for individuals to have a will. Why? Because sometimes you can, beyond those beneficiary designations, there may be other property and assets that you have, right? And so what are going to happen with those things? Or say for whatever reason, great example, this happened. An individual was kind of reevaluating his assets, his portfolio. He was updating beneficiaries and all these other different things. And there was one that for whatever reason, whether it was just paperwork misplaced and lost, designations didn't get updated, right? But in that will, he has it set out still what would happen according to his desires and his wishes. So it's one of those things that you still want to kind of have that in place, just to ensure that when everything is said and done, that it is going to go to who you have purposed it to go to. Okay. So one wonderful question there. And so the financial power of attorney, they can act on your behalf, open bank accounts, close bank accounts, enter into contracts, all those different things, right? To help you continue to grow and prosper. I mean, it's a good thing. I mean, you'll think like, whoa, no, I really don't need this. And the thing about it is everything that we share, we've seen it before. We just had a client that we needed to do a financial power of attorney for her because her son was unavailable, but he had some business he needed to take care of. And he needed mom to go out there and be able to open that bank account for him. Well, guess what? With that document, she's able to do exactly what needs to be done, and he can continue to do business and everything as he needs. Medical power of attorney. It appoints someone to make those healthcare decisions on your behalf. There are situations where these things are not in place, and say you have, married couples. There's certain ways that from the law it's supposed to happen. However, there can be conflict, division that's going on in a family, and say somebody's in a place in life changing decisions have to be made. Does this person stay on life support? Do they not stay on life support? Who is the individual to make that decision? You don't want there to potentially be a rift and a fight that's amongst the family in making these decisions, right? And then you're also able to, in that living will, to say what you do and do not want to happen, okay? And you want to just ensure that it's trusted individuals who you place in these positions, right? Someone that you can trust, someone that will not, take advantage and be reckless and all those different things. So ensure Ensure that it's someone that you can trust to put in these positions when you are planning and executing these documents. All right. Healthcare directives, the living will. What do you want to happen when it comes down to making the medical decisions for yourself, right? End of life care. I mentioned some of the things some people don't, for, based on their beliefs, they do not deal with blood transfusions. Some people are just like, look, I do not resuscitate, all these different things. So these are things to think about and have in place. And then you have the healthcare proxy who appoints who is that individual that you have to step into your shoes to make those decisions for you. Does power who is dealing with SSI, Medicare, and Medicaid? Yes, it does. And that is another reason why it is very important. Because, of course, let's just, a hypothetical, you have individuals as they're getting older, they need assistance, or maybe they're just not getting around as much, or maybe they're, not so much tech savvy, right? And there's a lot of things that they do. Well, having these power of attorneys in place, yes, they can come in and assist with SSI. They can come in and assist with Medicare, Medicaid, whether that's applying for it, whether that's having to communicate with them, execute various documents to ensure that they receive the benefits that they're applying for. We have a situation now that we were trying to assist a family in navigating. One of the individuals was ill, very ill, and they needed to get him transferred into a medical facility to receive the treatment that he needed. However, they needed the bank statements. Well, in order to get the bank statements, they need to have a power of attorney so that person can actually go and act on his behalf and say, look, I need these documents. And I will keep on reiterating, it's important. You never know what life is going to throw at you. You never know what's going to happen. And so if you plan ahead, it's going to not only make it easier for you, it's going to make it easier for your family. And then when the unknowns do happen, you're already prepared. You don't have to get ready if you stay ready. Okay. And so just the significance of these healthcare directives, you don't put your family in a position to have to make the hard decisions, right? There's stories out there where individuals have been on life support for years. Family either doesn't want to make the decision, it's too hard of a decision to make. They don't want to lose their loved one, right? Various reasons, not saying that either position is right or wrong, but if individuals have this in place, that even, yes, if I'm going to have life-sustaining, treatment, only want it for this long or that long. But you can prevent your family members from having to be in that tough spot of making that decision. Can you have multiple power of attorneys? No. So typically, what you want to have one, right? So now let me clarify. You'll have like a financial power of attorney, and then you'll have one that's dealing with like healthcare and medical decisions. But ultimately, even in those, you're going to have one. So say if I currently had a power of attorney and I had someone listed there, if I go and do another one, the previous one that I had is going to be voided out. It's basically revoked. And so in that situation, now you can have multiple individuals listed. So say that you have a power of attorney and your best friend is the first person who kind of has this authority, but they're unavailable or not able to do it. You could have a successor. So no, you'll have only one power of attorney. You don't want a lot of them, kind of floating around out there that can present a lot of problems for you and those who's actually trying to act on your behalf. But typically you're only going to have one. And like I say, one will be dealing with kind of like financial, all the general things. And then you have that other one, what we recommend as far as making those health decisions. Great question there. HIPAA authorizations and waivers. As you all know, patient privacy, if something's happening to you and, somebody's trying to go and get information, oh, when was the last time they got treatment? Or the doctor needs to know when the last time they had the surgery, what's taking place with that surgery. HIPAA authorizations allow individuals to be able to get the information and have the conversations that's needed, especially in that sphere of treatment and things that's going to be necessary for you. It enhances communication, transparency, and trust. And doctors, facilities, hospitals are not going to reveal this to an individual if they do not have the authorization to do so. Can you explain the difference between medical power of attorney and a living will? Yes. So to the extent that was not clear. So a medical power of attorney allows the individual to make the decisions on your behalf, right? So say that you were going in the doctor and for whatever reason, you can't communicate whether or not you want to receive a particular type of shot, right? Well, this person can say, well, yes, they want the shot or decline it. Okay. So that's kind of what a medical power of attorney is. Somebody stepping in your shoes to say yes or no to certain types of treatment. The living will is you actually setting out what you do and do not want, right? Do you, if you're in a situation that they need to resuscitate you, are you an individual who is DNR, do not resuscitate, right? Do you want all necessary measures to keep you alive? Or you're just like, look, if I can't breathe on my own, I don't want to be placed on a breathing machine. The living will sets out all of those parameters far as what you want to happen when you're incapacitated, life-saving measures are needed. What are those measures going to be, right? And in that, of course, your medical power of attorney will honor those things as well. So I hope that clears that one up. I hope that clears that up. And so even so look at this with your medical power of attorney. So for instance, like we're talking about individuals maybe needing medical records or needing to assist you with getting into type of facilities, and they need to go and be able to get records and things of that nature. Your medical power of attorney would be able to do that. But the only way your medical power of attorney is making decisions about, oh, do not resuscitate or not, if you do not have that living will, they will solely make that decision. But if you have the living will, then that medical power of attorney is honoring what you have already set out that you do or do not want when it comes to medical treatment and life-sustaining matters. So great questions. And yes, keep on throwing your questions out there in the chat. Great questions. Great questions. Okay. Oh, there we go. Okay. So we were talking about the beneficiary designations, and this was actually a question that came up about whether or not you needed a will if you already have these. So you're talking about non-probatable assets, right? This is your 401ks, this is your life insurance policies. This can also be your bank accounts, right? And so you designate individuals or entities like your trust to receive these assets from the accounts. It's so important to do these things because it's efficient, it's effective, and as I say, they do not go through probate, and so you save your family a lot of time and money. You can ensure that they pass directly to the beneficiary. So what happens? So say, for instance, your life insurance policy. When you pass, what your family needs to do, once they receive that death certificate, they'll provide the death certificate to the company who is housing the life insurance policy. And guess what's going to happen? They're going to release those funds directly to the beneficiaries. They don't have to initiate anything in probate court. When it comes down to the bank accounts, they work in a couple ways. Some individuals have a joint owner on their bank account. So say that you have a husband and a wife. Wife passes, husband is on there, the joint owner, non-probatable asset. That account is going to go directly to the husband. Okay. Say that you have a parent and a child on the account because the parent has gotten older, the child is now assisting them with everything. Well, the account will go directly to the child when the parent passes. But if you have an account and you don't necessarily want someone as a joint owner having that authority to kind of act and to utilize and do things on that account while you're actually living, you can designate a beneficiary on the account. And as we stated, the main purpose of this is so that it passes through probate. Once they provide the death certificate, the accounts will be turned over, or the assets, the funds in that account will be turned over to those who are listed as your beneficiaries at that time. The tip that you all should see on the screen: regularly update beneficiaries to reflect the life changes. You get married, you get divorced, you have children. You would think that people do this, but no. We've had a situation, these people have been divorced for years. I want to say over 20 years. Guess what? The gentleman did not update his beneficiary. Ex-wife was still listed. So guess who gets those proceeds? Ex-wife. Whether he wanted her to or not, she's still going to get them. So whether it was intentional or not, but you had some people who probably were not so keen in liking that situation. Okay, so you got to make sure we got to make sure that we're staying on top of these things. All right, I'm just checking our chat, making sure that I'm not missing anything. All right, and if you haven't, as you're joining on, still like and share the video. You can share, tell us where you're joining in from. As I was telling people too, if you have questions, things like that, go ahead and drop those into the chat. Okay. Final disposition. This is basically just detailing your end of life wishes, right? Do you want to have a funeral? What do you want that funeral to look like? Do you want to be cremated? These are decisions that you can make. You can make them. And, where would you like your remains to be? Some people have like a family plot, right? All the family is going to be buried in this location. If you're a veteran, do you want to have the military honors, right? Do you have the pre-need funeral plan? Have you already taken care of your funeral affairs? And if you do, you can have those things written out so your family knows. Like, there's a way to have all this process that when it's all said and done, everything is just like, hey, Mr. Jones knew he wanted to do this, he wanted to do that. And I promise you, your family will they love you regardless. They're gonna love you even more, because in that moment, it's just like, look, we just need to honor what he or she wanted. Declaration of guardian of your person in case of capacity. Okay. If you're in a state where you can't, you're losing your mental capabilities and being able to communicate and advocate for yourself, this is to protect vulnerable individuals, right? This is also to prevent the war that can happen between siblings. We dealt with a case before. Elderly lady, it's time for decisions to be made. Brother and sister are basically like oil and vinegar. They do not like each other. Oil and water. They don't like each other. And now they're in court battling it out as far as who's going to be appointed over mother to make the decisions. And then what happens in that situation? You have two people fighting. Judges say, "Hi, we're going to get somebody independent to come in." And so now someone who does not know your loved one at all is now making the decisions for them. It doesn't have to be that way. You can make these declarations and you have stability, you have continuity. Your finances are being managed. You have people who know you, who can actually advocate for you. Who would advocate for you better than your loved ones? There's also legal protection, the ability to plan for emergency situations. So I keep going back to make this point that when I say estate planning, it's more than just what's going to happen with your assets. There's a lot of things that you think about and you put in place, because you never know what is going to happen. You never know what tomorrow looks like. You never know what life is going to throw at you. But you can be prepared for it. You can definitely be prepared for it. Common mistakes to avoid. The very first one, when I first started, I said, look, everybody needs to have an estate plan. If you do not have one, we're going to provide information later on. Go ahead and book a call and just start the conversation so you can get the information to know what you need to be looking at. Not having a plan is the very first mistake you can make. It's the greatest mistake that you can make. Leaving assets unprotected, leading to unwanted outcomes. Wonderful question. What would you say to someone who feels they don't have enough assets to get a will? And this is what I'll tell you, Brian, and I hope I pronounced your name correctly. So when I was in the military, when our airmen first came in, we'll do a briefing, and they had a briefing with legal. And what we would tell them is, look, we need you to come on, schedule your time to get your will drafted up. And they're like, well, I don't have much at all. I don't need to get a will. Yes, you do. You want, even if you think that your assets are minimum. You never know what you will acquire. You never know what you will come into. You just, there's so many unknowns when it comes down to your future and what's going to happen before your time actually comes to leave this earth. You want to have it in place. And you can and at the time when you do your will, say you don't necessarily have, the house, the car, whatever these things may be. You can say, look, generally, if I have real property, I want it to go to, my best friend. Or I want it to go, if you have kids, I want it to go to my children. My residual estate, which means anything else, jewelry, furniture, all these different things. You want to have it. Prime example. We're handling a case right now. Young lady passed away. Only family that she had remaining was her aunt. She did some great things. On a lot of her accounts, she had everything listed out, as beneficiary. But guess what she didn't have? She didn't have a will. And so her apartment, here it is 6 months later, they're still trying to navigate getting the access so they can get all of her personal belongings, right? And there's going to be a way to do it. Yep, you get to probate court, you open some things up. But guess what? A will being in place would have made that process a little bit more easier. And so even when you think you don't need it, consider it. Have a conversation, right? Have a conversation. Like I say, later on in this call, we're going to share the link for individuals to schedule like that initial 15-minute call, just to say, okay, look, what does this all look like? This is what, so that way is the declaration. And so I hope that answered the question. My recommendation is get the will. And as I was previously stating, we try to make it, because it's beyond just the will too. I will say this real quick to that note. When we do draft individuals' wills, we do it as a package, right? So you're not just getting your will, you're also getting what we refer to like the medical power of attorney, financial power of attorney, your living will, right? What you want to happen to you as far as life-sustaining measures and treatment is concerned. All these different things encompass that. So it's more than just the will itself. So I hope that provides the clarity that's needed on that. Is the declaration of guardian of your person similar to the declaration of guardian for a minor child? So they're different. So of course, the declaration of guardian over your person is for somebody to be able to step in if you are at a place that you kind of need somebody to advocate for you, take care of you, things of that nature, right? Now, the declaration of guardian for a minor child is that if something were to happen to you, as well as say that the child, say mom passes, but father is still living. Well, father is going to be the person that takes care of the child, right? But if you have a situation where both parents are deceased, they can declare who they want to be the guardian of their minor children, who would take care of them, make decisions on their behalf, and all of those different things. So they're similar in the fact that they're labeled as guardians, but you have one as far as being able to take care of you as an individual if you encounter a situation where that's a necessity, and then you're having an individual who's able to oversee and take care of your children, financial decisions, legal decisions, school decisions, healthcare, all those different things as they're continuing to grow and prosper. Definitely wish we would have planned better for my mom. My brother changed after she passed and made processes hard still until this day. Her plan was we would always get along. And yes, that and we've heard this so often, which is the reason that we do this, which is the reason why we want to start getting people to that point that they're thinking about and say, hey, let's get things in place. Because unfortunately, when individuals do pass, our loved ones do pass, people do change. And whether that's from grief or whatever it may be, it is a time where people change, and it truly, it makes it hard. It makes it hard, unfortunately. It makes it hard. If a grandparent who wants to set up an estate plan and they are on their deathbed but are of sound mind, can they still set up an estate plan? Oh, wonderful question. So in doing all of this with estate planning, this is such a wonderful question. In doing all of this, you have to be of sound mind, right? You have to know what you are doing. You have to know the effect of documents that you are executing, right? So if you have an individual and they hadn't pre-planned anything, but they're at a place and they're like, deathly ill, And they're like, look, okay, I need to put things in place. I have these things. I need this to go to my grandchildren, or I need this to go to my children. I need to do X, Y, and Z. Long as they're able to, what they refer to, they're in sound mind, they can knowingly and willingly communicate with you, knowingly and willingly state, okay, this is what I'm trying to do. I want my home to be transferred to this individual. Even though they may be bedridden, they may be on their deathbed, they would still be able to set up their estate plan. Okay. And so what happens is, with all these documents, you have a notary who's there as well as witnesses. And so that notary is going to be able to communicate to them like, look, is this your last will and testament? You know, are you actually, is this the ladybird deed that you're executing, that when you pass is going to go directly to your son or to your daughter? So long as the individual is of sound mind, they will be able to execute the estate plan. And even if they're, you know, like I say, on hospice or wherever the case they may be at that point in time. But if they're of sound mind, yes, they will be able to execute those documents. And we've encountered that situation as well, where a loved one is sick, right? Health is declining rapidly, and they knew that they needed to get some things in place, and they reached out to us, and we understand the gravity of the situation, and always having these conversations with individuals, and also see what happens when those things aren't in place. Definitely did what was needed to make sure that they were able to get everything secured. So yes, wonderful question. And so it's one of those things too. And it's, in my opinion, I don't think that it's disrespectful or inconsiderate if you happen to know family members who are in those situations. You know, try to have the conversation. Hey, you know, you have these things. What do you want to do? You want to try to go ahead and get something, because you can't force anybody to do it, right? But at least try to bring up the conversation and, you know, be able to assist as much as you can. Does a doctor have to say they are of sound mind? So no, a doctor doesn't have to say that they're of sound mind. So typically what happens in these situations, the notary is the person. Now there, nobody's making like legal decisions as far as like mental capacity and things of that nature. But they're able to they're going to see if they can have a conversation with them, if they're understanding what they're actually executing. If it gets to a point that a notary is saying, well, no, this person can't communicate with me. I can't noted that they're doing it knowingly and voluntarily, and that they understand. And so if it's at a point that you're potentially having to get a doctor in place to see if someone has the mental capacity to execute documents, it's probably going to be a no, right? Now every situation is different, but to directly know, the doctor isn't the one who's making a determination of whether or not an individual is of sound mind. Now, if you encounter a situation, I will just do this quick pivot to that. So say for instance, you have a situation, I've seen it come up, where there's a will in place, and that will potentially maybe left some people out. And people were like, well, no, they were not of a sound mind. They were dealing with dementia. They were dealing with Alzheimer's. You know, they did not know what was going on. At that point in time, you're going to have a situation in dealing with probate, where you're having doctors come in to testify to, you know, treatment, what they seen, what they didn't see, what they observed, what they didn't observe. But initially, in these situations, again, they execute and they may be, like I say, hospitalized. The doctor isn't the one who's having to say whether or not they're of sound mind. Okay, so of course, not having a plan is the gravest mistake that you can do. Outdated documents. You have, life is changing, right? You get married, you have children. Those are times where you want to go back and you want to update your documents. Ignoring tax implications. Not planning for the state taxes can reduce the value passed to beneficiaries. Everybody that I talk to, I'm telling them, look, I understand where you are now, but you're also looking to the future. You're also looking to the future. Okay. And if you understand that you have the power to generate wealth, that should be your mindset. What I have now it's not going to even compare to what I'm going to have a year from now, 2 years from now, and things of that nature. Right. So it's always something to keep in mind. And then just poor communication, not discussing your plans with your family. Not discussing the plans with the family leads to confusion and disputes. And this is the problem that we see a lot of individuals facing, a lot of families facing. The communications are not had, or somebody understood something and then they didn't take the time to write it down. And so exactly what they did not want to happen is the reality. What they didn't want to happen became the reality because poor communication and not planning at all. Reviewing and update your estates, right? And this was when we were referencing outdated documents. After any major life event, you get married, you're divorced, you have children, your financial circumstances change or the laws change. Hey, let's review this. Let's see if there's some things that we need to do. And you can amend wills and trusts as needed. You can do that. Reassess beneficiary designations. That's the one good thing about potentially if you have a trust, right? There's different things and modifications that you can do, and you can update those beneficiaries on various counts. And just always consult with a professional to ensure compliance. I see posts here and there, and it's people like, oh, everybody needs to go get a revocable trust. Everybody needs to get an irrevocable trust. That may not be, it's not a one size fits all, right? And is there a lot of good information out there on YouTube, on the internet, all these different things? Yes, it is. There is. And is there a lot of misinformation? Yes, there is. So consult with a professional, right? Consult with a professional. At the end of the day, if you're going to do it right. If you're going to do it right. Can a power of attorney be put in place after a loved one has been diagnosed with Alzheimer's dementia? No, sir. If that individual cannot execute those documents to say, hey, so say, I'll give an example, so say you have a mother and a daughter, and the mother is now diagnosed with dementia. She really doesn't understand much at all. She's not recognizing people. There's no way for her to be able to execute a power of attorney to say, hey, I want my daughter to be able to make decisions for me, because you have to do it knowingly and voluntarily. You have to understand that you're giving someone the authority to make these decisions on your behalf. And so if they're not at a place to be able to actually communicate it and understand it, unfortunately, it will not be able to be done. How would I deal with this situation? A mother and father are married. Mother passes. It's in their will that the children they have will get the house. Remarries and moves her into the house. Then he passes away. Now the stepmother is okay. So that is an interesting concept, because husband is automatically still going to have a life estate in that home, but just by moving his new wife into the home, it doesn't per se just give her any right or interest into the property. So there's definitely going to be a dynamic in having to navigate that. And it's going to have to be evaluated, some documents looked at. But yeah, the stepmother just attempting to do so is definitely going to be a legal issue that I would present to you, just based on the information that you provided here, is not valid. Now, is it going to have to potentially go to probate to navigate all that, to get it sorted out? Potentially. But this would be one that I would say reach out to us, schedule a complimentary probate consult, and we can have that discussion and kind of assess it more, dig in a little bit deeper. But just right off, stepmother doesn't have an interest in that property. It's not even marital property at the time. When estate planning, what is the best option for a parent when they are on Medicare and Medicaid and may eventually need to go into assisted living? This is planning that needs to happen early on. So when it comes down to Medicare, so Medicare doesn't have any recovery program, but Medicaid does. And so what that means is that typically when individuals get older and say they're on Medicaid, and Medicaid is paying out for assisted living and all these different things, Medicaid can then come back and basically have a lien, if you will. I think that's going to be the easiest way to explain it. Have a lien on the estate. So say, for instance, that this individual had a home that they owned. Well, now Medicaid is coming to say, okay, they owed us $100,000. And then you have a home that's worth $300,000. They're now putting the family in a position to have to sell that home so that they can recover what they've paid out. The laws allow for them to come back and recover what they've paid out. So we refer to this as like Medicaid planning, right? There's like what they refer to as 5-year look back periods. There's things that you can do to ensure that your asset, your property, does basically not have to be sold, and then to be able to cover those assets. You have ladybird deeds, which is a thing that you have as well. And with a ladybird deed is what happens is when you pass, your home automatically goes to the individual that you've listed as the grantee, right? You have a parent, they're like, okay, I'm starting to plan these things out. Maybe I don't want to do a trust for a particular reason. I'm kind of evaluating the Medicaid thing and kind of just with the timing, how everything is. I want to do a ladybird deed. So as soon as I pass, the records are going to show that you own this home. So ladybird deed and transfer on death deed, they are similar in nature. Just the ramifications around it, right? Ladybird deeds, typically it just states that the grantor, if you will, basically the owner of their home, they continue to have control of it, to sell it, all these different things, right? But they're not subject to this 2-year claim period from creditors, right? So that's something to be mindful of, if you will. Transfer on death deed, it's the same thing. The property is going to transfer at the time of someone's death, but there is that 2-year period where you can have creditors who can still come to make claims against the estate. And so ultimately, in deciding like what's going to be best is when we're having that consultation with you, right? And we're trying to determine what it looks like. What are you actually trying to accomplish? And when we know that information, wonderful. Now we can say, look, this is what we recommend you should do, right? We recommend you should do this because this is how this tool is going to be utilized. This is how this tool is actually going to assist you in bringing about the outcome that you want. The difference between a trust and a will. So a will sets out how you want your assets to be distributed, right? I think that's a simplistic breakdown of it. The will sets out how you want your assets to be distributed. Once probate closes out, no one has any other control, no other additional oversight. If you had $100,000, $100,000 are going to go to your children in equal shares, and it's going to be done with. The trust, a trust passes outside of probate, right? And it's private. Nobody has access to the information. And in the trust, what you also have is controls, parameters that you can put in place. So say that you had that same $100,000. Well, in that trust, you can say, look, okay, I have these minor children. They can get X amount of money at 18, X amount of money at 21. So much of this money has to be invested in a particular stock, a particular portfolio, right? A trust allows you to truly put in measures that allows for continual generation of wealth, continual generation of revenue and profits. And like I say, it is a unique tool when it comes to having children, right? I tell people when I even in my consults, if I had the wisdom, the insight, and the knowledge that I do now that I did in my early 20s, oh wow, life would be looking even much better, right? It would be that much more better. But the thing is, developing in mindset. And so what you want to do is understanding that you can have parameters in place that your children would have to follow, right? The trustee would be able to say, okay, this is what happened. No, they said you can get a distribution at this age. You can get a distribution if you were starting a business. You can get a distribution based on milestones and criteria, right? These are things that you're able to do with a trust that you cannot do with a will. Okay. Does a will protect if I become incapacitated? So the will actually becomes effective, if you will, at someone's passing. So simply having a will doesn't hurt you nor harm you when you're incapacitated. So if you're in a need for decisions to be made and things of that nature, for someone to advocate for you, that's going to be why the medical power of attorney is important. Okay. All right. So I'm still going to be monitoring the chat. So if you all have questions, go ahead and throw them in there. I want to go ahead and briefly discuss the Pro Bono Initiative, so people can have this information. So what we do, one thing that we truly strive on is wanting to be an asset to our community, right? We're your trusted advocates for justice and peace of mind. But with that too, we also want to find ways to give back. So we do these pro bono initiatives, and what we're trying to do is so individuals who are not financially in a position to be able to put these things in place, is to assist them in doing so. Okay. And so it's our commitment to providing free legal services to individuals and families in Texas. It says Texas, of course. I'm licensed in some other states. As we continue to grow, we're going to reach out and get this thing going on a bigger scale. But right now, as we've launched this, individuals in Texas who can't afford representation, right? And this is from estate planning, which we were discussing today, to record expunction, and so on. With that, here are the qualifiers, okay? Individuals who are 55 years of age or older. What we are seeing is that our older population do not have things in place. We know that kind of, I would say, I guess us, the children, we're trying to talk to our parents and we're trying to say, hey, look, this is what needs to be done. And so 55 years or older, they're a resident of Texas, specifically within the DFW area, a U.S. citizen or qualified done citizen, and then they meet the specific income guidelines for the Texas Medicaid long-term care eligibility. Okay. Now, in order to apply, and there'll be links that's going to be placed in the chat too. Monthly payments for rent, mortgage, utilities, proof of citizenship or immigration status, proof of income, verification of any government benefits, and a copy of the existing will if they have one. If it's a situation where they just need to get updated, well, then just provide us with the previous one as well. Is there an age bracket to receive this initiative? Nisha, I hope that answers your question about it being 55 and up. And what I will tell people, we're also, for anyone who does not have an estate plan in place already, we're going to share the link for you to go ahead and schedule your 15. Okay, perfect. Okay, you've seen it. To schedule your 15-minute consult so that you can have the discussion. And I will say this again, because I know people may jump off and jump back in. Life is going on, right? Don't take the position not to act because you have the thought like, oh, it's not going to be affordable. Don't allow that to be the reason that you do not act, right? So when you see that link that comes up for you to schedule your consult, schedule the consult. One thing about us, we try to set our base fees because everybody's circumstance is different. So we try to set our base fees that individuals will be able to get these things in place. And there are so many different ways that we can work and get things together. Just, I don't want anyone not taking the steps to plan and prepare because it's like, oh, I don't think I can afford it. Don't let that be the one. Reach out to us. Let us have a conversation so we can figure out what needs to be done. Okay. What documents do you need? And so, of course, we just went over that. Just to reiterate it again. And the link is going to be placed in the chat. With that link, you will be able to fill out your application. Of course, we'll get everything reviewed. If there's additional documentation and things that you need, of course, we're going to be able to share that as well. And so this is just a quick recap. Estate planning essentials. Plan. Protecting your wealth, ensuring your wishes are fulfilled. And I hope you all notice one thing too, that because we have some questions like, oh, well, what if you don't think that you have all the assets and stuff? Everything that I said, I'm telling you, protect your wealth. You may not think that you have it now. I want to speak life into all of you. You have a dream, you have a vision. There is something that you have that individuals need. Go out there and do it. Okay? So you need to have your estate plan in place to protect your wealth. Okay? Take action. Start planning today. The links have been placed in the chat. Click on that link. Find a date and a time that is convenient for you and have the conversation. Have the conversation. It's going to be a benefit to you. Okay. A well-crafted estate plan provides peace of mind for you and your loved ones. It does. How do I protect minor children or dependents with special needs? Yes. So there is what's referred to as a special needs trust. There are things you can do to protect them financially. Of course, make sure they have the necessary guardians, if you will, the people who can step in to assist them in the future. But that's in those situations, that's what we recommend: special needs trust. Especially if you have this wealth that you're building, you also want that from a financial standpoint, because individuals with special needs qualify for certain benefits, right? But with those benefits, if they're showing that they have they're over the income guidelines, it could hinder what potential benefits they actually qualify for. So this is something to be mindful of in that space as well. Not only ensuring that you have someone who's trusted to be able to continue to assist them over oversight and everything that's needed as far as they're continuing to live life, but even from the financial aspect, putting things in place so that way they're not limited, hindered, or denied benefits that they may potentially qualify for, because it's showing that they actually have too much income. Okay. All right. So I know the questions have been coming in as we have been talking. If you have any additional questions, this is the perfect time to go ahead and drop those in there right now. Here's all our contact information. msalawfirms.com. You can go out there and see all the information about us in regards to our practice areas. We do not just do estate planning, we also do criminal defense, we also do personal injury. But you can get in contact with us, reach out to us if you have any questions. Follow us on our various social media platforms. We're on Facebook, IG, we're on LinkedIn, we're on YouTube. I encourage you all to follow us, because as I stated, one thing about us is that we're very passionate about continuing to show up in our communities, right? We want to be a trusted source. We truly want to be a trusted source. And that's what we're going to continue to make efforts to do. And ultimately, if you have something, we can assist you with it. I want to make sure that you're in the right hands of someone who can. Okay. So even if you're like, hey, I don't know if she does X, Y, and Z, reach out to us. Reach out to us anyway, because we do want to be able to assist you and help you in any way that we can. I'm truly hoping that this information has been helpful to you all. Now I'm going to remove that. There we go. I hope this information has been helpful. Like I say, I thank my team, Emil and Tremaine, for definitely being on and assisting as well, and sharing in the vision that we have as far as wanting to educate. Knowledge is power. Knowledge is power. And the thing is, now you all have some knowledge. You can go not only for yourself, but share it with your family, share it with your loved ones, right? We see the other side of this when we don't do these things with estate planning. Okay. I'm having the conversations with loved ones as well. You need to get these things in place. There's things that I need to do that I'm already doing this summer. I got to update some things. I got to modify some things. So even as we're out here sharing this information with you, trust and believe that we're doing it for ourselves as well. We have to. It's much needed in our communities. So definitely hoping that the information is helpful. Does it matter if they are on government assistance? Nisha, help me understand. I know you were asking about, so does it matter if they're on government assistance for the Pro Bono Initiative aspect? If that's what you're referring to, more than likely it's probably going to be more of a factor that probably qualifies them. So that wouldn't be a problem at all. So I'm gonna give it a second. I know sometimes it's a little bit delayed, but I want to see your follow-up so I can make sure that I answer that correctly for you. Yeah, I appreciate everybody. Kudos to you all for kind of taking some time out of your day on this Saturday to jump in and get this information. But like I said, there's going to be other pro bono initiatives that we're presenting out there. The next one, hopefully, that is going to be okay. Perfect. Yeah. The next one, hopefully, is going to be discussing expunctions and non-disclosures for people to get these records cleared up so that they can continue to be in a position to build the life that they're desiring for their family and loved ones. So with that, all the information that you need is in the chat. You can also go to our website to find out any of the information that you need. We look forward to having conversations with you all and getting your estate plans in position. Also having conversations with those who would be eligible for the Pro Bono Initiative, where we can get everything in place for you all. If my family qualified for the Pro Bono program and we want to add maybe a ladybird deed, can we do that? So what we will have to do, so we will do the will and all those different things. When it comes down to the ladybird deeds, we would need to have a discussion. What we probably can do is do a reduced fee on that one. But the ladybird deeds are not included in the pro bono program. I'll say that. But ultimately, we're going to make sure that you all are taken care of. So if you do qualify and that becomes a necessity, we'll have some discussions in regards to what that looks like and the next steps that needs to be taken. Great question. Thank you so much for that. All right, everybody. Well, until next time, you all have a wonderful Saturday. Continue to enjoy it. You all be safe out of there. And just remember, here at McCray Stewart and Associates, we are your trusted advocates for justice and peace of mind. Good day, everybody.